Services have developed national standards to protect patients' personal medical records. Gone are the days when our family physician kept our records sealed away in a locked cabinet someplace. As we all know, patient information is now electronically accessed and exchanged quickly. These new standards developed by the government are provided by HIPAA, H-I-P-A-A. That stands for the Health Insurance Portability and Accountability Act. And it provides protection not only for paper, but oral and electronic information, which creates a privacy system that covers all personal health information and other medical records in any healthcare facility that a patient might be found in. Another right is the right to participate in planning their own cares. That means a person has a right to choose a physician or caregiver. If an individual does not want a particular caregiver taking care of them, that's their right to refuse to have that. They have a right to choose the clothes that they want to wear in a healthcare setting, when they get up and when they go to bed, and certainly any change in healthcare status. They also have the right to refuse cares and treatment. Let's just say an individual decides they don't want to go down to the dining room, and that's practice for most individuals in a long-term care setting. Certainly it would be appropriate to ask the individual how come, but if they refuse, certainly their tray can be taken to their room for them to eat. Sometimes, however, it might just be that the individual is feeling a little bit shaky and unsteady and would welcome going to the dining room, provided that they had an arm of a caregiver or a wheelchair. So be sure to ask as well. Also, they can refuse end-of-life decisions. Many times they can refuse CPR. Individuals can refuse artificial breathing or medications other than pain meds at the end of life. The last that I'll talk about is the right to voice and file grievances. Grievances also known as complaints. That might be complaints about anyone or anything in a healthcare setting. Many facilities utilize the services of an ombudsman. An ombudsman is an impartial individual who investigates complaints and acts as an advocate for the patient and family. This ombudsman is provided with the individual's medical records, any other information, as well as the resident, in order to seek facts related to the complaint. Also, the resident has the right to voice any grievance without fear of retaliation or that something bad could happen to them as the result of their doing so. In 1998, the state of Wisconsin passed what's called the Wisconsin Caregiver Law. This law protects citizens from caregiver misconduct. I would like you now, please, to watch a videotape that's been graciously provided by the Department of Health and Family Service as it talks about the Wisconsin Caregiver Program.
Whether your workday starts in the morning, afternoon, or evening, chances are it's often hectic and stressful. Maybe it's getting the kids to school on time, or caring for a sick relative at home. Stress is a fact of life. You understand that because your job offers its own stressful situations. Providing care to others is an important and rewarding role. Whether you are providing care in a community-based residential treatment facility, a nursing home, a hospital, a client's home, or any other adult health care facility, you are important to the emotional and physical well-being of those entrusted to you. No one knows better than you the challenges you face while carrying out that trust. Some days you may feel as if you have too many duties and too little time to respond. In the face of on and off-the-job stresses, your ability to serve some of our most vulnerable clients depends on your ability to remain calm. You need to remain focused and aware of your behavior and the behavior of other caregivers to ensure safe and compassionate quality care. The state of Wisconsin, to help ensure that our most vulnerable citizens receive the ultimate in safe and compassionate care, passed the Wisconsin Caregiver Law in October of 1998. The Caregiver Law requires many healthcare facilities to report incidents of caregiver misconduct and some injuries of unknown source to the Department of Health and Family Services. Today, we're going to look into several aspects of the Wisconsin Caregiver Program. Understanding the caregiver program can protect those you serve and prevent caregiver misconduct from occurring. First, we want to define some terms. How does the Wisconsin Caregiver Program define caregiver misconduct? What is an injury of unknown source? Next, we will review some case examples and discuss what you saw and heard. Are these examples of caregiver misconduct? Finally, we will explore why it is important for you to immediately report to a person in authority any injury or any incident that could result in client injury or distress, and what happens after you report an incident at your workplace. After reviewing the definitions, the case examples, and considering the benefits of reporting, you will have a clearer idea of how the Wisconsin Caregiver Program will protect you, your coworkers, and your clients. First, let's look at what we mean by caregiver misconduct. An act of caregiver misconduct may fall into one of three categories: abuse of a client, neglect of a client, or misappropriation of a client's property. Abuse is defined as an act that contradicts a healthcare facility's policy and procedures and is intended to cause harm. Now, the harm or intended harm may be physical, mental, or emotional, and it may result in pain, injury, or even death. Some examples of abuse include sexual harassment or inappropriate touching of a client, hitting, slapping, pinching, and kicking a client. Abuse also includes acts that intend to threaten, intimidate, or frighten. The key to abuse is that the caregiver intended physical, mental, or emotional harm. Next, let's look at the second category of caregiver misconduct. Neglect is defined as the intentional carelessness, negligence, or disregard of policy or care plan which causes or could be reasonably expected to cause pain, injury, or death. The results of neglect may be very similar to those of abuse. The major difference between abuse and neglect is that in the case of abuse, harm was intended. In neglect, the caregiver does not intend to harm the client. However, in the case of neglect, the caregiver's actions were completed on purpose in a careless or negligent way. Again, neglect goes beyond obvious physical neglect to include disregard for clients' rights. Neglect may cause mental or emotional damage that results in anxiety, fear, depression, withdrawal, or any number of similar behaviors. Remember, an incident becomes a case of neglect when the caregiver has behaved in a careless or negligent manner that could be expected to cause harm, even though the caregiver never intended to harm the client. Let's look at the third category of caregiver misconduct: misappropriation of client's property. The common word for misappropriation is theft. Misappropriation includes actions such as theft of a client's money, credit cards, or jewelry, or misuse of personal property, such as using a client's phone or other personal property without consent. Use of a client's identification or property for personal gain can be considered misappropriation. Finally, an